Yeah. So in the last class we have completed conduct of bailment. We'll do the revision. कैसे करेंगे? फटाफट. So what is the meaning of bailment? The word bailment is derived from a French word bailer, which means to deliver. To delivering something to someone for temporary purpose. I am giving the bottle to Rajini. Giving the bottle to Rajini. She said, I'll return it after the class. I am giving the pen to Rajini. She said, I will return the pen after the class. I am giving the bag to my friend. He said, I will give it tomorrow. ऐसा नो सर बेलार बेली बीच में क्या है bailment means delivery of the goods by one person to another for specific purpose. Which purpose? The purpose can be any purpose. Stitching, repair, using, ornamenting, changing, है ना? Delivery the goods by one person to another for specific purpose. Once purpose is achieved, goods must be returned. Goods must be to the same person are disposed of according to directions of the person delivering. So you have to give it back to me or give it back as per my instructions to my wife, my father, in the same manner or in the altered manner. I give the bike, you are going for that washing of the bike, giving back in the same manner. I gave the gold biscuit, you are making it as a ornament, altered manner. Done. So here the person who is delivering the goods is said to be bailer. The person to whom it is delivered is said to be bailee. Even my friend, I am giving my bike to my friend. So after one day he will return it back to me. Yes sir, no sir. Bailment. Amen. Essentials of the bailment. There must be delivery of the goods. There must be. So delivery means giving the position from one person to another person. The delivery, custody without delivery is not a bailment. I give one example in the regular class. So Rajni bringing something to that silver shop for making some changes to silver article. And I said it will take 3 days time. So she's keeping the box in my shop. She's keeping that ornament in the box. She's locking the box. She's taking the box key with her. Whether bailment is there? No, because she's not giving me position. And delivery may be actual or symbolic or the constructive. I am giving the water bottle, actual delivery. I am giving the car keys, that is the symbolic delivery. Which delivery? In case of constructive delivery, position will not change. It will be in the same position. Constructive means assumed, presumed. Then we discussed there must be contract. Every contract of bailment must satisfy section 10 of the Indian Contract Act. The contract can be expressed, the contract can be implied, and consideration is not necessary for the bailment, that is gratuitous bailment. We discussed the same thing in the consideration chapter also. There must be some purpose. Purpose should be specific purpose. The purpose may be lending you, giving you, depositing you for the safe custody, repayment or repairs, conversion, anything. Some purpose must be there. And there must be return of the goods. Once purpose is achieved, goods must be returned in the same manner or the altered manner to the same person or the as per his instructions. And bailment applicable only to movable goods. It is not applicable to immovable property. So we know the what is bailment and essentials of bailment and types of bailment. Two types basically, based on the benefits, based on the reward. Based on the benefits, three types. For the benefit of the bailer, I am going to somewhere, I am leaving my dog in my neighbor's place. Only I am benefited, bailer. And for the benefit of the bailee, my friend is going to trip with his girlfriend. I am giving my bike. I am not getting any benefit, only is getting benefit. And I am giving the cloth to tailor for making the dress. He is getting the money, I am getting the dress. Both are will be benefited. Next, on the basis of the reward, two types, gratuitous and non-gratuitous. Gratuitous without any consideration. Non-gratuitous with some consideration. I am giving the car to my student. He is having a that car garage, car repair shop. So after repairing, student said, "Sir, you didn't pay anything. He's not charging any amount from me. Gratuitous bailment, but he's charging some amount. Non-gratuitous bailment. In case of gratuitous bailment, I am liable to disclose only the defects which I know. Very very important. In case of non-gratuitous bailment, I will be liable for the defects, whether I have the knowledge about the defect or not. Very, 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 very important. I kept so many stars also on the regular lecture. Star, star, superstar. Next term, bailer rights, duties, bailee duties, rights. First one, duties of the bailer anta. So first duty to disclose the defects. Gratuitous bailment only known defects he must disclose. Non-gratuitous, whether you have knowledge or not, you have liable for the defects. I kept so many stars. How many stars? So since I kept so many stars, no, that means it came so many times in the exam. And ordinary and extraordinary expenses. Who will bear the ordinary expenses? Bailey. Extraordinary expenses? Bailer. So I go the back to mechanic for the repair. है ना बेटा? That grease, है ना बेटा? Water, Bailey. And engine खराब हो गया, Bailer. Ordinary expenses? Bailey. Extraordinary? Next, indemnify the Bailey. Indemnify the Bailey. It is a duty of the Bailer. If Bailey getting any loss because of my defective title, who is it? Bailer, defective title. I have to compensate the Bailey. Bolo. If Bailey suffers loss due to defective title of Bailer, he has to compensate the Bailey. Next one, last one is the right to receive back the goods. Once repair is done, no beta, he will inform me, sir, your bloody car is dead, please take back your car. It is my duty to take back the goods. If I don't take back the goods, no beta, I am keeping my goods at my own risk. Kuch kharab ho gaya to I have to bear the loss. Done. Moreover, I have to compensate the Bailey for the parking expenses. Done. Next, rights of the Bailer. What are my rights? I am giving the car to mechanic. First one, right of termination. If I give the bike to mechanic for the repair, but he is using the bike for his personal purpose, contract will become voidable at the option of the Bailer. I can claim damages also. First, next one, right to demand back the bailed goods. In case of gratuitous bailment, I can demand back my goods even before completion of the duration of the bailment, a purpose of the bailment. Right to claim back the right to claim the compensation from the wrongdoer. So I am giving the car to Abdul for the repair, and someone Sai is damaging the property. So who can file a case on this wrongdoer? Bailer and Bailey. Then so I am the bailer. He is the Bailey. He is the wrongdoer. He is breaking the car glass. So I can file a case on the wrongdoer. So last one, enforcement of the Bailey duties. All your duties nothing but my rights. Done. Next one is the duties of the Bailey. Duties of the Bailey. First duty, you should take the reasonable care of the bailed goods. I give my car to you. You should take care of my car as if your own car. Still goods are damaged, then Bailey will not be liable. If you're negligent in taking care of my goods, you have to compensate me. Next one, unauthorized use of the goods. Generally, Bailey should not use the goods without any authority. If you're using my goods for your personal purpose, no, contract will become voidable at the option of the Bailer, and you have to pay the damages to Bailer. It's your duty. Duty not to mix your goods with my goods. Generally, Bailey should not mix his goods with Bailer goods. If Bailey is mixing the goods with the consent of the Bailer, they have to share the benefits proportionately. And without the consent of the Bailer, if you're mixing the goods, no, if it is separable, you have to bear the separation expenses. If it is not separable, you have to compensate the Bailer. Done. Next one. Duties of the Bailey. What are the duties of the Bailey? First duty, duty to return the goods. Once bailment is completed, you have to return the goods to Bailer. If you don't return the goods to Bailer, you are keeping the goods at your own risk, and you have to compensate the Bailer. Second one, duty to increase in the goods. Very, very important. So after bailment, if there is any increase in the bailed goods, so that increase should also be given to Bailer. Cow is having the calf, or that plant is having a small tree, है ना बेटा. Otherwise shares are getting the bonus shares. Share किसका है बेटा? Bailer का. Bonus shares also Bailer का. Cow किसका? Bailer का. And calf also Bailer. We have to done the increase in the goods also, accretion. Next entry, adverse title. Not to set up the adverse title. Bolo, Bailey cannot say that Bailer has no right to bail the goods. Last one is the rights of the Bailey. First one, right of the compensation. So we have to pay for the services of the Bailey for the repair charges, for example, in our example. Yes sir, no sir. Otherwise he can return the goods. So joint bailers center. In case of the joint bailers, we can return the goods to any one of them or all of them. Next, right to file a suit for the wrongdoer. So goods are damaged, no beta. Bailer, Bailey, some third party is damaging the goods. Even Bailey can file a case on the third party. And right to be interpolate. Interpolate means injunction. If any third party is claiming the goods, so Ramcharan is giving the car to ఇడెవడో ఎన్నంట Navadip. है ना बेटा clear ना some stranger came he's claiming the goods he's having the RC all the documents the Navadip said I will return the goods with me only until ownership is decided you people go to court of la fight है ना बेटा so interpret means injunction a junction last one is the right of lien so bailey has the right to return the pledged goods until bailed goods until his charges are paid next one is the termination of the bailment last concept in the bailment of termination first one so actually we bailed the goods for 3 months how many months 3 months is expired bailment is expired and achievement of the objective I gave the cloth for making the dress stitching is completed bailment also completed next inconsistent use of the goods I gave the bike to mechanic for the repair using for the personal purpose mechanic using the bike for personal purpose it is voidable at the option of the bailer we can terminate the contract by death of the bailer and bailment comes to an end and gratuitous bailment can be terminated by the bailer at any time next there is a small concept called lien lien means right to retain the position of the property belongs to another person so for example Rajani has to give me 1,000 rupees he is not giving the 1,000 rupees one fine day I have taken her mobile I said I will not give the mobile until you pay my 1,000 rupees इसको बोलते हैं lien lien is of two types particular lien and general lien particular lien means right to return only those goods on which service is rendered actually Rajani gave the watch to me for the repair I repaired the watch previously it was not working now it is working after changing cleaning and washing and changing the battery it's working yes sir no sir so charges are 500 rupees I said I will not give the watch unless you pay me 500 service are given on the watch keeping the watch only particularly which lien right to return only those goods on which service are due we can exercise this right if and only if I'm exercising some labor on the goods because of that term है ना बेटा I am providing the services as per the terms and conditions and I must be in the lawful position of the goods and there is no credit because of my services there is additional value on the goods because previously it was not working now it is working and I can exercise this lien only after providing the complete services general lien that means right to return any goods for any money due actually money is due on the bike but I'm returning the watch general lien which lien general lien is not available to everyone it is available only to banker so there is a default on the prepayment of home loan he can freeze the that FD also available to factor means agent so Rajani is my agent she has to collect the money from the customers so I have to pay commission to Rajani 10% I am not paying the commission to Rajani she said I will not pay the money from the another customer's collections until you pay the commission for the old customer and this customer next Warfinger is the warehouse nearby the seaport we storing the some goods last month we are not paying the rent next time I am storing some other good the Warfinger owner said I will not release unless you pay rent for the previous goods and these goods attorney of the high court that means advocates so advocate has a right to return the documents unless we pay the fees for the previous case and this case policy brokers that means insurance agents who provide the marine insurance so we have to pay commission to agent otherwise they have a right to keep the documents unless we pay the commission for the previous insurance and this insurance right to return any goods for the any money due done clear next concept is the termination of the lien so when lien comes to an end surrender of the position lien means holding the position of another so I give back the position lien will be lost and payment of the money why I am taking your goods because you are not paying my money you paid the money I have to give the goods release the goods lien is lost and abandonment that means waiver I only said I will not exercise the lien even you don't make the payment so lien will be lost next one is the finder of lost goods there is a constant contact between the finder and loser here the loser is deemed to be bailer the finder is deemed to be bailey for example Ramchandra lost his bag है ना बेटा I find the bag है ना बेटा so here he is deemed to be bailer I deemed to be bailey then next duties of the finder of the goods so duty what is my duty I have to take the reasonable care of that bag and I cannot use the goods in the bag and I have to make the efforts to trace the real owner then these are my duties and what is my rights I have right to retain the goods until you pay the legal charges which charges if you are announcing any reward but I have a right to return the goods until you pay the such reward And right of resale, generally I should not resell the goods, but I can resell the goods when I am unable to find the owner, and I found the owner but unable to pay the find the lawful charges. And goods are perishable in nature like flowers, milk, curd, fruits, and searching expense exceeds the two-thirds of the value of the article, I can resell the good. I kept a star also here. Done. Next one is the pledge. Contract of the pledge. Pledge means a special kind of bailment. Pledge is a special kind of bailment. Bailment means any purpose. Pledge means giving the some goods to the pawnee and taking the loan, where it is a security for the repayment of the loan. Simply security for the repayment of the loan. So if you see the definition of it, pledge means bailment of the goods as a security for the repayment of the debt or the performance of a promise. Since you perform your promise, no, I'll keep your goods with me. Simply girvi, simply takattu. Here, bearer is said to mean pledger or the pawnee, bail is said to mean pledge or the pawnee. And essentials of the pledge. Every pledge has to satisfy essentials of the bailment, because pledge is a bailment, and there must be the bailment must be only for the security against the repayment of the loan. It is applicable only to movable property, that is goods. The goods must be in existence. There must be delivery of the goods by pawnee to pawnee. There is no delivery, no bailment. Next, rights of the pawnee. So rights of the pawnee similar to rights of the bailee, and he has the right of the lien. So pawnee has the right to exercise the lien on the pledged ornament until you pay the principal, interest, and other expenses. Next, ordinary expenses. Who has to bear beta? Ordinary expenses, pledging. External expenses, pledger. Next, rights in case of the default by pawnee. If pawnee makes a default but is unable to repay the principal and interest, first I have a right to file a case. Then I have a right to resell the goods. I can resell the goods only after giving a notice. After giving a notice, if I am reselling, no, but if there is any deficient, actually you have to pay 1.2 lakh. How much? Since you are not paying, I am selling. I am getting 1.5. Extra 30 I must refund. And you have to give me 1.2. Since you are not paying, I resold, but I am getting only 80. So I can recover this 40 from you again. Done. Next one is the duties of the pawnee. So similar to bailee, we should take the reasonable care of the pledged goods, not to use those goods without any authority. We must return the goods to the pledger, and we should not mix his goods with our goods, and we should not act inconsistent with the terms and conditions, and we have to return the any addition in the pledged goods, like a cow is having calf, and dog is having the puppy, then share is having the bonus share. We have written those things also. Next one is the rights of the pawnee. Rights of the pawnee is nothing but rights of the bailer. And if pawnee makes a default in repayment of the loan, and pawnee may give the notice of resale, before reselling we may make the full payment, we may take those goods. Done. Duties of the pawnee, nothing but the duties of the bailer. That is, pawnee is liable to repay the debt and compensate for the extraordinary expenses, disclose the defects, and if pawnee is getting any loss due to our defective title, we have to compensate the pawnee. And if there is any deficient after reselling the goods, we have to pay. Actually, we have to pay 1.2. Unable to pay, he sold the gold getting only 80k. So extra 30k we have to pay or not? So these are the duties of the pawnee. So last concept is the pledge by non-owners. We will discuss this in the SOGA, sales of goods sector. With this, revision of the bailment, pledge, lien, finder of lost goods is completed. So why a delegate cannot further delegate his authority? Because principal, while appointing the agent, principal have the confidence and faith towards the agent's skill and confidence, skill and qualifications. So the same qualification other person may not have. That's why agent has to perform the duties personally. Agent cannot further delegate his authority to some third party. We are having two exceptions. First one is the sub-agent. Next one is the sub-surety agent. In case of sub-agent, see here, I have a shop, Srinath Gupta Kirana and General Stores, and SR Nagar, to take care of SNR, I am appointing the Charan. Yes sir, no sir. Then Charan said to me, Srinath sir, I am unable to manage everything. So let me take my friend Abdul. But I will be the face of the shop. I only will manage everything. So Abdul will take care of the back end work like purchases, collections, and all. Yes sir, no sir. So here SG is the principal, Charan is the agent, Abdul is the sub agent. Between original agent and Abdul, he will become the principal, he will become the agent. So generally there is no direct contact between the sub agent and the principal. Generally, he will report to original agent. Original agent will report to principal. If Abdul is appointed with my consent, he said to be properly appointed sub-agent. If properly appointed, no. If Abdul is purchasing some goods from third party for the shop, but who will be liable? Principal will be liable to third parties. Then we are opening one more branch, beta, Banjara Hills. And Banjara Hills is controlled by the Ganesh. Ganesh is appointed by the Charan itself. He said to be substituted agent. He directly report to principal. Simply, if a person is reporting to original agent, he is a sub-agent. If the agent is directly reporting to principal, he is said to be substituted because both are equal. Substitutes means equal. He is the head of the SNR, he is the head of the Bandara Hills. If third agent is reporting to original agent, sub-agent. If third agent is directly reporting to principal, substituted agent. Done. So generally in the following cases, sub-agency will be valid. If it is allowed by the custom, if nature of work requires the delegation like building work we discussed, and the principal is agreeing expressly, principal is agreeing impliedly, and emergency requires, we can also delegate the work to some third party. He said to be properly appointed sub-agent. If agent is properly appointed, principal will be liable to third parties. If sub-agent is improperly appointed, then who will be liable? Original agent is liable to principal and also third party. Remember that. Then rights and duties of the agent. Rights and duties of the agent. First one, duty to follow the instructions. ये exam में एक बार आया बेटा. So agent has to follow the instructions of the principal. I said to agent, we purchase the goods for 7 rupees, we sell it for the 10 rupees, profit 3 rupees. So, but she sold the goods for 9 rupees. How much loss I am getting? 1 rupee. So, she has to compensate me and that agent has to compensate. First one, duty to take care of care, skill and diligence. Agent has to take care of the principal goods as if your own goods. Next, otherwise you have to compensate principal. Duty to render the true accounts. So, at which price we are purchasing, at which price we are selling. So, all these things you have disclosed to principal. Duty to communicate with the principal. If you are unable to perform your duties, no. If you are getting any difficulty, so you have to ask the principal for performing your duties. Duty to not deal in your own accounts. In my shop, you should not sell your own articles, beauty products and all. Or kirana shop, beta. You should not deal on your own, and you shouldn't make any undisclosed profits. Duty to pay the sums received. Whatever the amount you are getting, no, you have submitted to principal. Duty to set up, not to set up the adverse title. Adverse title means denial of title. Agent should not say that the principal has no authority to sell the goods. You can't say that I am not the owner of the goods. And duty to maintain the trade secrecy. How we purchase, how we sell, you should not inform it to our competitors. Duty to protect the interest of the principal in case of the death. But death of the principal agency comes to an end. Still, you have to protect the interest of the principal unless principal's legal representatives attends the shop. Last one, duty not to delegate the authority generally. Generally, agent has to perform the duties personally. He should not delegate his authority to some third party. Done till now. Next term, rights of the agent, right of the remuneration. So agent is eligible to get the agreed remuneration if it is agreed. If it is not agreed, reasonable remuneration. Agent is eligible to get the remuneration only completion of the whole agency. And in case of the guilty of the misconduct, if agent is guilty of the misconduct, is not entitled to get any remuneration. And if I am unable to pay the remuneration to agent, no, agent has a right to return the principal's money until his claims are paid. And right to return the goods also. If I am not paying his remuneration, no, he can access the lien on the goods. So if I am not paying his salary, he can return the principal money, he can return the principal goods also, A or B or both also. And right to be indemnified. If agent is getting any loss due to defective title of the principal, because of my fault you are getting a loss, I have to compensate you. Then next then agent's authority. Agent's authority means power of the agent to bind the principal with his activities with third party. So who's the owner? Principal. Who's selling? Agent. To whom? Customer. Even agent is selling it to customer, principal is liable to customer. It means right of the agent to bind the principal by his activities with the third party. इसको बोलते हैं agent's authority. It is two types, express authority and implied authority. So I express it to agent, you sell the goods, I will be liable. Express authority. Generally, whenever agent is selling, no, but I am liable to third parties. Implied authority. And scope and extent of agent's authority, it is applicable only to lawful things, but not to unlawful and illegal things. So we can agent can make me liable only for the lawful things, but not for the unlawful and illegal things. Next, restrictions on the agent's authority. So agent is having a power. I am restricting the agent's power, agent's authority. Generally, whenever agent is purchasing the goods, who will be liable? Principal is liable. One fine day, I said to agent, don't purchase the goods on my behalf. I only will purchase. Then, so we purchase the goods from the porting. So, there is a restriction on the power of the agent. If third party know about the restriction, agent's power is restricted, and third party know about the restriction, still third party entered into agreement with the agent, whether principal is liable. If third party is ignorant about the restriction, whether principal is liable, yes, principal will be liable. We discussed the example also, right? Next step. Relationship with the principal, principal relationship with the third party, it is three types: named principal, unnamed principal, undisclosed principal. So first one, where agent is contact for the named principal. Shop name is Srinath Gupta Kirana and General Store. But who is sitting in the shop? One is sitting in the shop. So if agent is acting within his authority, who is liable? Principal. If agent is acting beyond his authority, if work is separable, not separable. If work is separable for authorized work, principal. Unauthorized work, agent. Work is not separable for everything. Who is liable? Agent is liable. If fraud is committed by agent relating to principal business, who is liable? Principal. Agent is doing some fraud not related to principal business, who will be liable? Agent. So notice can be sent to agent and notice can be sent to principal also. Next, where agent act for the unnamed principal. A principal na unnamed principal means so shop names Sai Ganesh Kirana and General Store, Durga Kirana and General Store. So principal name is not there. Whether it is there? No. So third party disclose the fact of the agent. Third party know that I am the owner of the shop. Then who will be liable? Principal. Third party don't know that, don't know about my name. Then who will be liable? Agent is liable. Where agent is acting for the undisclosed principal. So one is said to customer, I am not the owner. Somebody is the owner. Then customer is asking, who is that somebody? I will not tell the principal name. So agent said, I will not disclose the principal name. So third party does not discover the principal name. Then who will be liable? Agent, because he said I don't want to disclose my principal name. But third party know that I am the owner of the shop. Then who will be liable? Third party discovers the existence of principal. I will be liable. So actually he said I will not disclose my principal name. But I entered in the shop. I said to customer, you talk to me. I am the owner. Then who will be liable? Principal discloses himself. Done. Then we discussed personal liability of the agent. Generally for activities of the agent, who is liable? Principal. But in the following cases, agent is personally liable. For example, agent is staying in the foreign country. Which country? Customer will not go to foreign to file a case. Then agent is personally liable. Next, where agent is acting for the undisclosed principal, just now we discussed. Agent is liable. Who is liable? Agent. So one said, I don't want to disclose my principal name. Then agent is liable. Where agent is acting for the incompetent principal. Principal is minor, is insane, he is insolvent. Then agent is personally liable because there is no agency at all. Because principal must be competent to enter into contract. Where agent is acting for the non-existing principal. Principal is not there first of all. So she is doing fraud because principal is not there. Agent is not there. Then who is entering into contract? Agent. Agent is liable. Where agent's authority is coupled with interest, very important. Here agent is a partner come agent. I said to Vani, I have to give 10 lakhs rupees to Vani. Vani, you sell my building. You sell my building. I am authorized to sell my building. I am the principal, you are the agent. So if you sell the building now, you will get 80 lakhs. Out of 80 lakhs, you keep 50. Remaining, give it to me. Here in this transaction, she is interested or not, she will get the money if she is selling only. इसको बोलते हैं agents coupled with the interest. It cannot be revoked by the principal at any time. Just like that. Done. Next, where agent is receiving or pays the money by mistake or fraud. Agent is doing the fraud. Then who will be liable? Beta? Agent only liable. If it is not related to principal business. Next, personal liability by agreement. So by express agreement, agent said, I will take the personal responsibility. Then agent is liable. Exceeding authority. If agent is acting within his authority, who will be liable? Principal. If agent is acting beyond the authority, and by customs and usages. Because of the trade custom also, agent may be personal liable. Pretend agent. Pretending means acting. है ना बेटा? So here agent is doing the fraud. Then who will be liable? Agent is personally liable. Next one is the termination of agency. Termination of it is three types. By mutual agreement, I said, Vani, don't come to my office from tomorrow. She said, even I don't want to come, sir. Agency is terminated. Vani said to come to office, but I said, please don't come to my office. Revocation by principal. And I want Vani as my agent. But she said, I am resigning, I am getting married, I will leave. Renunciation by the agent. Actually, when I am removing here, I am staying in Mumbai, agent is in the Hyderabad, customer is in Nizamabad. I am removing here, I am removing as an agent on the 10th. And it came to know about Anjali on Vani on the 15th. Customer came to know this on the 20th. For me, agency ends on 10th. For agent, it ends on the 15th. And for customer, it ends on the. Actually, we are appointing the agent for the 3 years. How many years? After 2.5 years, only we are removing. We have to compensate for 5 months or not? Yes, sir. And SG is the principal. Vani is the agent. And Sindhu is the sub-agent. Sindhu is the sub-agent. Sindhu is the sub-agent. When I am removing the agent, automatically sub-agency also ends. Termination of agency will lead to termination of the sub-agency also. Clear? Next one. Agency comes to an end by the operation of law also. Like completion of the business, I am appointing the Vani to sell the building. Building based the agency ends. Death and insanity of the principal or the agent, by death of the principal or agent, agency comes to an end because one year. Insolvency of the principal must be competent to enter into contract. By insolvency of the principal, agency also ends. By expiry of the time, I am appointing the agent for how many months? 3 months. 3 months expired, agency also ends. Destruction of the subject matter, I am appointing the agent to sell the build car jal gaya, agency also ends. By dissolution of the company, so directors are the agents of the company. By dissolution of the company, agency relationship between the directors and company will also come to an end. Last one, business becoming unlawful. I am appointing the agent to sell the liquor. Liquor business become unlawful. Agency also comes to an end. So with this, we have done with the revision of the contract of agency. Done. So remaining part we will discuss in the next class. Have a great time. Enjoy the day. Prepare well. As is signing off. Take care. In the next class, we'll do the scanner. Done. Yeah. So welcome back, sir. Let us start the revision of the contract of guarantee. So what is a contract of guarantee? Contract of guarantee is a contract to perform the promise. Perform the promise or discharge the liability. Perform the promise, discharge the liability of a third party in case of third party default. Which party? So that means 3 parties will be there here. One is the principal, one is the surety, one is the creditor. How many parties will be there, beta? 3 parties will be there. For example, there is a person called Rakesh. Who is he, beta? Rakesh. R for Rakesh, R for Rich. Yes sir, no sir. There is a person called Paramesh. P for poor, P for principal data. Yes sir, no sir. There is a person called Suresh. S for Suresh, S for surety. Three parties will be there. One fine day, Paramesh is in need of the money. Who is in need of the money? Paramesh. Then is approaching Ramesh. Ramesh or Rakesh? Rakesh. Rakesh. Can you please give me 1 crore, 1 lakh rupees? He's having money. Who is having the money? Rakesh is having. Then Rakesh said, yes, I'm having the money. I will give the money if you give me some security like gold, silver, land. Then Paramesh said, I'm a gentleman, but I don't have anything to give you as a security. Then Paramesh is having a friend of Suresh. Then he went to Suresh, Arey Suresh, I need 1 lakh rupees. Can you please arrange? Then Suresh said, even I don't have money. Do one thing. Go to Rakesh and ask the money. He will make the payment because he's a rich in our circle. But Paramesh said, Arey, yesterday only I went to Rakesh. He's having the money, but he don't want to pay. But he has a good name in the market. Who? Suresh. Then Suresh made a call to Rakesh. Rakesh, pay the money to whom? Paramesh. Paramesh will repay. If Paramesh is unable to repay, I will repay. Here, who is giving the money? Rakesh. He said to be creditor. To whom it is given? Paramesh. He said to be principal debtor. So who is given the guarantee for that? Suresh. Is called as the surety. Here, three contracts will be there. Three independent contracts between the surety and the creditor, and one is between the creditor and the principal debtor. Third one is the principal debtor and the creditor. These three are independent contracts. It may be void, it may be voidable, it may be void, it may be voidable, but it will be valid contract. Yes or no, sir? To enter into contract of guarantee, principal debtor, he may be competent to enter into contract, competent to enter or not. He may be competent to enter into contract or not. However, surety must be competent to enter into contract. He must be competent to enter into contract. That he should be major, he should be someone, he should not be disqualified by law. So, who is giving the money? Creditor. To whom? Principal debtor. Who should repay? Principal debtor. If not, who will repay? Surety. How much surety will repay? What are the liability to the principal debtor? That much amount surety will pay. That is, here principal amount is the 1 lakh and interest is the, for example, 50,000 rupees. Totally 1.5 lakh. So if principal debtor is unable to pay, who has to pay? Surety. That means liability of the surety is equal to liability of the principal debtor. It is known as the coextensive. Coextensive means equal. Liability of the surety is equal to liability of the principal debtor. So here, who has to pay? Principal debtor has to pay, repay. His liability is primary liability. Which liability? He has taken the money, he has to pay. If he is unable to pay, who has to pay? His liability is secondary liability. His liability is secondary liability. And arise if principal makes the default. Yes or no, sir? Then so contract of guarantee is not contract of utmost good faith. Not utmost good faith. Still, not utmost good faith. Still, principal debtor and creditor should not hide the material information. Don't hide the material information with a surety, which will affecting his liability. If liability is not affected, surety's liability, they can hide. Otherwise, they should not hide. Done. And see here, surety is giving the guarantee to creditor. What creditor is giving to surety? Nothing, frankly speaking. There is no something in return. Something written is there. See, here, surety is giving the guarantee to creditor. Creditor is not giving anything to surety. Money given by the creditor to principal debtor is the consideration to surety. Stranger to consideration. Stranger to done. Yes sir, no sir. See, here, for example, Rakesh is giving the 1 lakh rupees to principal debtor, and principal debtor also giving the 2 gold rings to surety. Gold rings to creditor. उसको बोलते हैं securities. उसको बोलते हैं securities. Then, if principal debtor is unable to pay, who will pay? Surety will make the payment to creditor. then creditor has to give that securities to whom beta? Surety. Done na? If principal debtor is unable to pay, if principal debtor is unable to pay, who will pay? Surety will pay to creditor. Then creditor will leave the picture. He gave the money, he is getting back his money. Previously, principal debtor has to pay to creditor. Now creditor is getting back his money from the surety. Then creditor will leave the picture. In the place of the creditor, who will come beta? So now principal debtor has to make the payment to surety. इसको बोलते हैं subrogation. Subrogation. That is surety stepping into the shoes of the creditor. Done. Yes sir, no sir. Sometimes, for example, beta, principal debtor become insolvent. From official receiver, only 70% is recoverable from the principal debtor. That means creditor is recovering only 70k from the official receiver of the principal debtor. Yes sir, no sir. So how much is asked for this guy? 30. So only 30,000 rupees can be recoverable from the surety. It's called the reduction of the liability. If principal debtor become insolvent, if the official receiver of the principal debtor is giving only part of the amount, to that extent the surety liability will reduce. How much he gave actually? 1 lakh. How much receiver is giving? 70. So remain 30, who has to pay? Surety. Sometimes surety will tell, hey beta, I will come as a surety if another surety also joins with me. So who is this center? Satish. Suresh. Suresh said, I will join as a surety if Satish also joins with me. They said to be co-sureties. So how they have to share this guarantee? They may share 50-50 ratio. They may share 28 ratio. They may share any other ratio also. But within that cap, everybody has to share equally. We discussed one example also. Within that cap, there is maximum liability is 20 lakhs. Maximum liability is 80 lakhs. But we are giving only 10 lakhs. How they have to share? 5 lakhs only. And if agreement is silent, nothing is specified how much we have to share. 70 or 30. They have to share equally only if agreement is silent. Then sometimes what will happen? Creditor is giving the 1 lakh rupees to principal debtor. Yes sir, no sir. And creditor has to receive the 20. He is giving the 1 lakh. Giving the 1 lakh. Yes sir, no sir. He is giving the 1 lakh rupees. But principal debtor is teaching to surety's son. For example, 20,000 rupees worth of the classes. So this surety can ask. Actually, creditor, you gave him 1 lakh. You gave him, and you have to give him 20k because he was teaching to your son. You can adjust this 20k. I will give you only 80k. Surety has that right also. Then, so this is the major concept of the contract of guarantee. Clear now? So major part is completed. We'll discuss one by one. Moreover, discharge of the guarantee. If this person and this person doing something without informing the surety will be discharged. Without the consent of the surety, principal debtor and creditor changing the interest, changing the amount, changing the place, changing the rate of interest, changing the duration, altering the terms and conditions without informing to surety will be discharged because there is an novation will be there. Old agreement will be discharged. Then we'll read one by one better. So it is a contract to perform and discharge the liability of the third party in case of the third party default. Who said surety? To whom? Creditor. Who is the third party? Principal debtor. If he is unable to pay, I will pay it to you. It is agreement between these two people. Here, three parties will be there. Surety, who is giving the guarantee. Principal debtor, on whose behalf guarantee is given. Creditor. So, to whom guarantee is given? Surety, principal debtor, and creditor. It is a three-party agreement. Which agreement, beta? Three-party. Three parties will be involved here. One agreement will be principal debtor and creditor. It is a principal contract. And secondary contract will be creditor and surety. This is contract of guarantee. And there is an implied contract between the surety and the principal debtor. One contract is here. One contract is here. One contract is here. The three contracts are the three independent contracts. Then next, essentials of the contract of guarantee. There must be some purpose. The purpose of the contract of guarantee is to secure the creditor. Secure the next. Agreement can be oral. Agreement can be written. Consideration anta. Money given by the money given by the creditor to principal debtor is the consideration to surety. Done. Stranger to consideration. Competence of the parties. Principal debtor can be competent to enter into contract. He can be incompetent to enter into contract, but surety must be competent to enter into contract. Existence of the liability. Conflict of guarantee will come if and only if there is some liability between the surety and creditor and the principal debtor. If there is no liability, surety will not enter into picture. Done. Next, no concealment of the material facts. Which facts? Principal debtor and creditor should not hide the material facts with the surety, which will affect the liability of the surety. If it is immaterial, they can hide. Done. Done now. And every contract guarantee has to satisfy section 10 of the Indian Contract Act. Types of guarantee. Specific guarantee, it is a guarantee given for the single transaction. Which how many transactions? It cannot be revoked because it is a single transaction guarantee. Next one is the retrospective guarantee. Guarantee given for the past transactions. Which transactions? It cannot be revoked. It cannot be because it is a single transaction guarantee. Next one is the prospective, single transaction guarantee, specific guarantee. Guarantee for the past transactions, retrospective. Guarantee for the future transactions, prospective. Fidelity guarantee is a guarantee given for the good behavior of the person, good conduct of a person. I am appointing, so here we discussed. So, surety is there, agent is there, and this, who is in Abdul, who is in Satish, who is in Navadip. So, I said to Abdul, you can keep Navadip as a cashier. Navadip as a cashier. If we leave the shop with the cash, I will pay that money. He's a good gentleman. Which man? Good gentleman. So, guarantee given for the conduct of a person, behavior of a person is said to be fidelity guarantee. Absolute guarantee is a guarantee without any condition. And condition guarantee is a guarantee which is subject to some conditions. Maximum 1 lakh only. First file a case from the principal debtor, then only I will be liable. Continuing guarantee important, but this one also little important. And continuing guarantee is a guarantee given for the series of transactions. Continuing guarantee comes to an end by notice of revocation or by death of the surety. Done. Next, nature of the guarantee. It is coextensive. Coextensive in nature. Coextensive means liability of the surety is equal to liability of the principal debtor. Liability of the principal debtor is equal to liability of the surety. 1 lakh plus 30k. So liability to surety also 1 lakh 30 only. Liability surety may also limit his liability. Surety said to creditor, you can give any amount to principal debtor, but I will give you maximum 1 lakh. If principal debtor makes the default. Next, surety liability will arise only on default made by the principal debtor. Principal debtor is honest, genuine, gentleman. Surety will not enter into picture. Next, original contract between the principal debtor and the creditor. This may be valid, voidable. This can be voidable. It will be valid contract only because these three are independent contracts. Which contracts are? Next, rights of the surety. Rights of the surety. What surety can do the principal debtor? What surety can do the creditor? What surety can do the another surety? First, rights of the surety against the principal debtor. 3 rights will be there. 2 rights will be there. Right of subrogation, right of the indemnity. So, once surety pays the liability of the creditor will leave the picture, then surety will enter into the place of the creditor, then principal debtor has to make the payment to creditor. Usko bolte hain subrogation. That is, surety stepping into the shoes of the creditor. Once surety discharges the liability of the creditor. Next one is the right of indemnity. Right of. So, whatever the losses happened to surety because of default made by principal debtor, principal debtor has to compensate the surety. That can be principal, that can be interest, that can be other lawful charges. Next, rights of the surety against the creditor. First one, right to claim the securities. Actually, creditor give 1 lakh rupees to principal debtor give the gold articles. Yes sir, no sir. He defaulted. Who? Principal debtor. But who paid the money? Surety. To whom? Creditor. Creditor has to give that gold articles to. There is right to claim the securities, right to claim set off. Just now we discussed. Actually, how much creditor gave? 1 lakh. How much principal debtor supposed to get? 20k. So we can set up that we can pay only 80. Done. and right to get the reduction in the share, right to get the reduction. If principal debtor become insolvent, from official receiver we're getting only 70%. So his liability is reduced by the 70 because already receiver gave. His liability will be only remaining 30%. Next, right to require the creditor to terminate the services center. So surety can ask the creditor don't give anything subsequently. For past transactions, I will be liable, but don't give anything subsequently. And right to require the creditor to sue the principal debtor first. So surety can ask the principal creditor first file a case on the principal debtor. He will make the payment if you file a case. If not, you can come to me. I will give the payment. Then last one, rights of the surety against the other surety beta. The four rights are there beta. How many rights beta? Four rights. First one, right to claim the contribution. Right to claim the actually 50k liability, surety guarantee liability, but everything is paid by S1 only. So S1 can take the 50k from the S2. Next, right to share the benefits. So actually, creator give the two rings, to gold rings to S1 because he's paid everything. So S1 can recover the 50k from S2, and S2 can recover one gold ring from the S1. If you remember. Next one, right to release of the co-surety. Even creditor is releasing the one of the co-surety, other co-surety will not be released. Yes or no, sir, he has to contribute to other co-surety. Nothing but joint promises. A, B, C jointly promised to give return rupees to D. The same concept from performance of a contract. Next, they may bound in the different sums also. They may contribute equally, they may contribute differently also. But if they contribute differently, within that limit, they have to share equally. If agreement is silent, they have to share equally only. Done, everyone. Next one is the discharge of the surety. Discharge of the surety. It is four types. Beta. First one is the revocation. So by giving a surety can give the notice to creditor, guarantee will be comes to an end. And by death of the surety, guarantee will comes to an end. By notice also, by novation also, if they're entering into new agreement, surety will be discharged. But however, revocation will apply only for the future transactions. For past transactions, he will continues to be liable. By conduct of the creditor and the principal debtor. These are again 4 to 5 types. That is variation of the terms without informing to surety. Composition with the principal debtor, that is entering into new agreement, generally for the compromise. Next, by giving the more time to principal debtor without the consent of the surety. And promise made by the creditor not to file a case on the principal debtor without informing to surety. By losing the securities by the creditor, then surety will be discharged. Next one, by invalidation of the contract, that is the surety and principal debtor hiding the material information. Which information? Last one, co-surety is unable to join. S1 said, I will join as a surety if S2 also joining. Whether S2 is joined, no. S1 will be discharged. Contract of indemnity. Contract of indemnity. Indemnifying means making good of financial loss. Making good of financial loss. Contract of indemnity means if you're getting any loss because of me, because of someone, I will take your loss. I'll compensate you. That is the contract of indemnity. So it's a contract by which one party promises to save the other from the loss caused to him by conduct of the promiser himself or conduct of the any other person. Best example is the insurance. If we have taken the car insurance, insurance company said, if something happens to your car because of me, because of someone, I will take your loss. Yes sir, no sir. Here two parties will be there, beta, indemnifier and indemnity holder. So who is ready to compensate is known as the indemnifier, like insurance company. Who is being compensated is said to be the indemnified or indemnity holder. That is a policy holder. So clear na madam? And every contract of indemnity has to satisfy the section 10 of the Indian Contract Act. There must be promise to save the other party from loss, and loss may be due to conduct of me or some other person also. It may be expressed, it may be implied also. Actually, accident is happened. So what we can claim from the insurance company? That is the cost involved in the insurance. That is a car value. And if you're not giving my money, no, I may get any loss, no. That damage also you have to compensate. Since you're not giving my money, I filed a case on you. So all other sums paid to the advocate can also recover from you. And with this, we have done with the revision of the contract of indemnity also. So in the next class, we'll do the scanner. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care.